Hello, everyone, and thank you for logging on to what is our final KKC webinar of the year. So happy holiday season to all of you, and thank you for again logging on today. The webinar today is to focus on year-end considerations in regards to your estate plan. So particularly timely because it is year-end. And a lot of the suggestions that I'm providing are not something that's necessarily specific as to things that really need to be completed, done prior to year end. Some are, some aren't. But it's mostly just a checklist of things that year end is a good time to just generally reevaluate. So the checklist and kind of the items I'm going to be discussing today is mostly along those lines of things you should be aware of. Even if it's not necessarily now, this year end that you do all of these things, something that should be on your radar as to periodically review. So to dive right in, one of the big things that has been talked about by estate planners a lot within the last month or two is proposed changes at the federal level in terms of various estate planning concepts. So there's been discussions about potential changes and the federal estate tax exemption and other issues under the umbrella of the Build Back Better Act that's, again, currently being debated at the federal level. So the good news is that a lot of the changes that they've been talking about or that's been published that was included in some earlier rounds of the bill haven't been implemented. Looks like they probably won't be implemented. But it's good to review just very quickly what the things were that were being discussed that had estate planners all up in a tizzy for a little bit, just because it's good to know what they've been talking about, just because even if it's something that wasn't implemented this time around, because it's been brought up means it's not unlikely that it's going to come up again at some point in the future. So even though it may not be enacted in this round of legislation, there could be a bill next year or sometime after that includes these kind of same changes that they were talking about. So the big one that I mentioned too was a potential change in the estate tax exemption. So to do, again, a really just quick overview, the estate tax is a tax that applies to only certain estates, and the estate tax is only going to be applicable to your estate if you own a certain amount of assets. So the federal estate tax, which is the one that they were talking about in the Build Back Better Act, the current federal estate tax exemption, so the amount of assets that you can have before the estate tax is going to apply, as in this year, it was currently and still is $11.7 million. The change that they were talking about was reducing that back to about $5 million, or actually they're talking about, and again, I'm not going to get into a lot of the specifics, reducing that exemption back to down around $5 or $6 million. So that had a lot of people really worried who higher net worth, who have a lot of assets, thinking that they had this really large exemption available to them, that they weren't going to be subject to the estate tax. Now, all of a sudden, they were talking about having that reduction implemented and having it implemented in place as of January 1st, 2022. So again, that's something that they ultimately, or at least in the most current round of the bill that I've seen, they've taken that out. That is no longer included. Another piece that they were talking about was also too, not only in the Build Back Better Act, it's something President Biden had talked about on the campaign trail and it's kind of been whispered and discussed in other areas, not necessarily just in the Build Back Better Act, was a loss of stepped up basis. And this is a tax concept where basis is essentially what you paid for something. So you paid $200,000 for your house. Again, just as a broad simplification, your basis in your house is $200,000. If you then sell your house, it's 10 years later, it's worth $300,000. There's $100,000 worth of gain there. And there's a lot of exceptions and exclusions to this rule, but I'm just trying to give you a general hypothetical so to illustrate the concept of basis. So in that concept, your basis was $200,000 because that's what you bought your house for. You sell it for $300,000. There's $100,000 worth of gain there that, again, you would have to pay taxes on. This concept of stepped up basis says if you inherit gifts or you inherit assets from somebody, your basis in that asset is not what the person's basis was who you got the asset from. So for example, Mom and dad bought their house for $200,000. They pass away. Again, 10, 15 years later, the house is now worth $300,000. You inherit the house from mom and dad. Your basis is not mom and dad's $200,000 basis. You get a stepped up basis because you inherited the asset. Your basis in that house is the fair market value as of the date you inherited it. So when you inherited it and it was worth $300,000, that $300,000 now becomes your basis. So if you were then to sell it for $300,000, there's no gain. There's nothing that you need to pay taxes on. So that's a really important and really valuable estate planning tool that we've had for years and years. And they were talking about kind of doing away with that, again, with some exceptions. But it was something, again, that had everybody really concerned because this was such a common, widespread way to transition ownership of assets to beneficiaries with very minor or with very beneficial tax results to the beneficiary of those assets. So, but again, thankfully, in this round of legislation, they said they're not doing that. There was also some other proposed changes. I'm not going to get too far into detail with these, again, just to make you aware of what they were talking about. Largely other tax changes related to tax treatment of specific types of trust known as grantor trusts. They were talking about doing away with valuation discounts for non-business assets. And again, I'm not going to get too far into detail of what the specifics of those are, but just to say that these were really big concepts that were going to upend a lot of plans that had already been put in place and kind of changing the rule book on estate planners that we've had in place for many years. So a lot of these were really substantial changes they were talking about. But again, thankfully, it looks like in the most recent round of legislation, none of these changes are included anymore. So estate planners everywhere have, had a sigh of relief. So now we know, at least it doesn't seem like for now we're going to have to really rush and try to do any year-end changes to our clients' estate plans because it looks like none of these changes are going to be implemented, or at least they're not going to be implemented for January 1st, 2022. So we can all breathe a little bit easier, at least for now. Generally speaking, though, to get back to that just general year-end checklist, one of the big things that is specific to that does need to be accomplished prior to year end is annual gifting if you're going to be taking taking advantage of the annual gift exclusion. What the annual gift exclusion is the IRS says you're allowed to gift X amount of assets, dollars, every single year to people without the need for you to pay any taxes. And the tax in this case we're talking about is the gift tax. In that annual exclusion, that amount that they allow you to gift every year is $15,000, at least for 2021, is $15,000 per recipient. So for example, if you have 3 kids, you can give each of your children $15,000 each year, and it's not going to trigger the need to file any gift tax returns or pay any taxes. If you go over that $15,000 per recipient per year, so if you give your kid $15,000 one month, and in January, and then in August, you give them another $5,000, the total amount of gifts you gave that recipient in that 1 year is $20,000. You would have been over your $15,000 threshold. That triggers the need to file that gift tax return. So the annual exclusion is $15,000 per year per recipient, and that's the amount for 2021. The IRS is actually increasing that amount to $16,000 per year per recipient as of January 1st next year, but it's still the basic concept, the same basic concept. That's all not the maximum amount you're allowed to give a recipient every single year without the need to file a gift tax return. So if you do have plans to make gifts this year and you haven't done any gifting yet in 2021, and you still say, well, I have that kind of free $15,000, why don't I take advantage of it? You would need to do those gifts before December 31st this year to use that $15,000 annual exclusion that you have available to you in this tax year. The good news is also, too, married couples, you each have your own $15,000, or if it's next year, you each have your own $16,000. So in 2021, married couples can actually give $30,000 per year per recipient, again, just because each spouse has their own $15,000. So if you're looking to give larger amounts to your kids or grandkids or other beneficiaries, whomever it might be, again, so long as you keep it at $30,000 or less total between the spouses, you're still going to stay below that annual gift exclusion again. So you're still going to have benefit, take advantage of that annual exclusion benefit that the IRS offers and not have to pay any taxes. You can give more than $15,000 a year. And that's a question I get a lot is, or a comment that I hear is that, oh, well, the IRS says I can only give $15,000 a year. And that's not true. They say you can give as much as you want. It's just the first $15,000 that it's only the first 15 that's free. If you do more, again, that's going to trigger that need to file the gift tax return, but the first 15 is still free. So that's something I always like to point out too. If you do have inclinations towards making larger gifts, if you want to help your child put a down payment and purchase a house or pay for a wedding or kind of any just larger general gifting that you're doing to any of your beneficiaries, you can go above the $15,000. Again, it's just anything above that annual exclusion amount just triggers the need to file a gift tax return, which needs to be filed by April 15th of the year following the gift, same as your regular income tax returns. If you are inclined to gift, there's certain assets that it makes sense to gift. One is from an estate planning context for higher net worth couples that again might be worried about having to pay some type of estate tax. So again, if they have a substantial amount of assets, they want to try to get some of those assets out of their estate, pass them on to their intended beneficiaries now. We recommend gifting assets that are likely to appreciate. So if you already have a substantial amount of assets and think you might be close to that estate tax exemption amount, and you have, for example, the vacation house out at the Cape that right now is worth $500,000, but the way property, the real estate market is going, you think, in 5 or 10 years, it's going to be worth $750,000 or $1 million, or securities. You purchased a certain amount of securities in a company that or some other entity, and then you think it's going to really appreciate in value and just go through the roof. Those are good assets to gift because you can gift them out now at the lower value. So that house at the Cape, you can gift it out now while it's worth $500,000. And when 10 years from now it's worth $1 million, you still only had to report that $500,000 gift. So you got an extra $500,000 essentially for free gifted out just because you gifted it while the value was still somewhat lower. So it makes, number one, it makes sense to gift those assets that are likely to appreciate in value from an estate planning context. From a tax context, it makes sense to gift assets that have a high basis. So again, I talked a little bit about basis previously, where that being really basis, an oversimplification of what basis is what you paid for it. Assets that have a high basis are good ones to gift because if you gift the vacation house, you gift the stocks over to the kids and they are low basis assets. So if it's the family compound that you inherited from your mom and dad, or it's been passed down through the generations for years and years and years, and maybe you have a really low basis in it, you gift it to your kids. Lifetime gifts do not get stepped up basis, they get carryover basis, which means that whoever receives that lifetime gift does keep your basis in the property. So if your basis in that vacation house that you gifted to the kids is $200,000, but when the kids go to sell it, it's worth $600,000, now the kids are stuck paying taxes on that $400,000 worth of gain. So you don't want to give necessarily low basis assets because that's going to result in a lot of taxes potentially being due by your beneficiaries down the road, but rather give them high basis assets. So again, even though the beneficiaries are getting those carryover basis, so they're just taking what your basis is. If you already have a high basis in those assets, and then so your beneficiary gets that high basis too when they sell, again, it blunts the tax impact for them, so and achieves a better tax result. So our two recommended types of assets we gift, again, just to summarize, assets that are highly likely to appreciate, and two assets that have a high basis already. So another thing, I've talked a lot about let's gift to get assets out of my estate if I'm worried about estate taxes. But again, those exemption amounts are so high that not many people are worried about paying an estate tax. So you say, I don't have $11 million. And also I should clarify too, that's the federal estate tax exemption currently is at $11.7 million. There is a Connecticut estate tax exemption that's currently at $7.1 million. It is going up to $9.1 million next year. So again, but even though it's lower than the federal, it's still quite high. So if you say, you know what, I'm not a multimillionaire, I don't really have to worry about estate taxes, why would I do any type of gifting? Well, one, it's to, again, just general gifts. Maybe you plan to, rather than let kids inherit assets, long when you pass away, maybe it's beneficial to give the kids kind of their inheritance while they're living, help them start out while they're younger. See the benefit that they're reaping from those assets while you're still alive. Maybe that's a reason that you want a gift. Two, also, if you run a business, could be just part of your basic succession plan. At some point, you want to retire, and the kids or your key employees are going to be taking over the business. You might be wanting to gift ownership of that business, again, just to transition it over to the next generation. Also, gifting can come into play if we're worried about long-term care costs. If you think at some point down the road you will need in-home caregivers, you might need to go into a skilled nursing facility, and you're worried about protecting assets. Gifting is one way, again, so long as in Medicaid and long-term care is really a whole nother animal that I'm not going to get into in this presentation today. But just suffice to say, one way to protect assets, so long as you do it properly and within the appropriate timelines, is to gift assets. So if you want to preserve, make sure the house is protected and you don't have to sell it, and that you're still leaving that behind for the kids as their inheritance, gifting might be one way to do that. So again, there's a whole bunch of reasons to gift. So it's not, again, gifting these amounts is not necessarily just important for folks who have millions of dollars, but for everyday people, gifting can be something, one, that you were planning to do anyways, or two, something that you just might generally get some benefit from. So year-end gifting is one of the few items that if you want to do, you want to take advantage of that annual exclusion, that $15,000 amount, you do need to get that done before year end. And if you want to also do a lot of gifting really quickly, you want to go over that 15,000. It's not uncommon to do a gift in December. So this year you would do a gift this month to say, here's my $15,000 for this month I'm taking advantage of. Oh, in a couple of weeks, all of a sudden it's a new tax year. It's January. Now you get your $16,000 exemption, annual exemption, or annual exclusion. So December 31st, you make a gift of 15,000. January 1st, you make a gift of 16,000. You manage just to gift a whole lot of stuff pretty quickly. But as far as the IRS is concerned, is 2 tax years. So something else to keep in mind. Second, and year end, again, is generally just a good time to evaluate where things stand with your estate plan. So take out your wills, your trusts, your powers of attorney, and just read through all those documents. Check to make sure everything is still appropriate. And the big things you're looking for, one is going to be your fiduciary appointments. Who has been appointed as the executor under your will? Who's been appointed as the trustee under your trust? Who's been appointed as the guardian for any minor children that might survive you? Take a look at all those fiduciary appointments. And fiduciary is just, again, a title for someone that you've chosen to do a job for you. So again, executor, a trustee, a power of attorney, a guardian. Take a look at all the people that you've appointed to serve in those roles and consider, are those still the most appropriate people to serve? Are they, maybe, again, you did these while the kids were a lot younger. And so maybe now, again, you're not so much worried about guardian appointments and such, but now your kids are grown and you say, well, previously I had my brother or my sister-in-law or somebody else serving as my executor under my will or as trustee under my trust. Maybe now that should be my adult children. They live nearby. They understand what's going on in my life. They're the people now that are best suited to serve in those roles. So maybe consider updating. Something that I actually faced in my own estate plan, I have 2 little kids, and right after my kids were born, my husband and I did a will, and the biggest thing for us in there was the guardian appointment. We wanted to make sure we chose who was going to be in charge of looking after our kids if something happened to us. Our alternate guardians under the will was relatives of ours who at the time were married, but now they aren't. So, but our will still said this couple, and again, who are now divorced. So that was something we immediately wanted to go in and just update and remove, because the person who, again, we no longer have a relationship with, we didn't want to be still included in our plan. So life changes in terms of, again, births, deaths, marriages, or even just general passage of time might mean updating those fiduciary appointments make a lot of sense. Also, probably the bigger one that most people think about is the distribution provisions in the wills and the trust. Where did I say I want all of my stuff to go to? Does it still make sense? Again, really common for parents who, like myself, as soon as you have kids, you get that will, you get that trust in place. A lot of times you have a whole bunch of protections in there to say, I don't want my kids to inherit a bunch of money when they're little. Here's all the people in charge. Maybe there's some kind of trust. If you did that 20 or 30 years ago and now your kids are grown, maybe you don't need all of that anymore. Maybe you do. Maybe your kids are grown, but they're really not great at managing money, or they're in a high risk profession where you're worried they're going to get sued. But just those provisions might have changed just simply because of the passage of time. Or also, again, maybe, God forbid, one of the people that you've named in those documents has passed away. Have you, in your prior documents, did you provide an alternate for where those assets would go if someone did pass? Or maybe now that someone passed, you have more specific ideas of where you would want them to go, and it's different from what you had in that initial document. So again, just generally a good time, read through those documents, make sure your fiduciary appointments are still appropriate, make sure your distribution provisions are still appropriate. Just make sure the plan that you have in place still does what you want it to do. Also, a lot of times documents that were done are really, again, if it's been a long time since you've done these, there's been a lot of changes in tax laws and in just general state laws, which may have impacted your plan or may mean that you can simplify your plan. For example, estate tax exemptions many years ago were a whole heck of a lot lower than they are now. So there were hundreds of thousands of dollars exemptions rather than multi-million-dollar exemptions. So a lot of times folks have credit shelter trusts or all other types of more complicated planning tools in place because they were thinking that they would have to pay an estate tax, where now because exemptions are so high, they don't. So maybe you can kind of do away with a lot of that stuff and simplify your plan. So again, just year end is a good time to, everybody's talking about resolutions and things you want to get done. So reviewing your estate planning should definitely, estate planning document should be on that checklist. Again, just because you want to make sure your documents still do what you want them to do. Something that I also find is pretty common is a lot of times, particularly again, if there's been a lot of time that's passed since you initially had done planning, is that maybe at the time you did it, the primary concern was just getting that will in place or just getting that will and trust in place. And maybe at the time, it didn't seem all that important to do incapacity planning documents. So you didn't do powers of attorney or medical directives or living wills. So when you're going through and reviewing these documents, not only look at just what I say in the documents I have make sense, take stock of what documents you don't have. Do I have the power of attorney and the medical directive and living will? Because if you don't, that's something that you should definitely, again, add onto your list of things of, does that make sense for us now? Maybe as you're getting older, all of a sudden it seems more important to have those documents in place that it may have 10 or 15 years ago. So again, a lot of things to evaluate in terms of the documents themselves. Also, the primary estate planning goal for a lot of, or if not all of my clients, is they say, when I pass away, I wanted to have it be simple and easy. I don't want my assets to go through probate. And the primary way to avoid probate is to make sure you know how you own your assets, because the only assets going through probate are assets that are owned individually in your own name. So if you maybe, again, you went through the estate planning process many years ago and you said, great, I've structured ownership of my assets in such a way such that they're not going to have to go through probate. And again, the primary ways to do that are to make sure your assets are owned jointly between yourself and another person. The assets have beneficiary designations on them. So like a life insurance policy, retirement accounts, making sure you have named beneficiaries on those accounts. Those will, if those are completed and those beneficiaries are named, those will also avoid probate, or making sure assets are owned in trust. If your assets are structured in that way, then great, you manage to avoid probate. But again, if time has passed, maybe ownership of your assets has changed too. One example I saw fairly recently with one of my clients is I met with them several years ago. We put a plan in place. We made sure that we structured their assets to avoid probate, so they were jointly owned or they had a beneficiary designation on them. And a few years later, they sold their house, bought a new house, but for various reasons, the house ended up being titled just in the husband's name and wife's name never made it on the deed. So even though years ago we had set up this plan that worked and it was great, they've bought and sold new assets. So now again, it's good that they came to see me because I was able to recognize that. We can say, okay, well now we need to again kind of restructure those assets, make sure they're still not going to go through probate. So just do a periodic review of what are your assets, how do you own them? And again, make sure it's in line with what you want. If you want to avoid probate, again, you need to find a way to make sure to make those assets not be individually owned, because that way you're going to, if they're not individually owned, you can keep them out of that probate process. Similar to that, I mentioned assets passing through beneficiary designation go outside of probate. So again, that's a really great planning tool. But you should also make sure you know what those beneficiary designations are. A really common one I see all the time is I set up my 401k years ago, maybe before I was married, before I had kids. My parents are still the named beneficiaries on those accounts just because, again, I didn't have a spouse. I didn't have kids at that time. It is so important to go back and review those beneficiary designations to make sure they're current. Essentially, your beneficiary designations should mirror what you say in your will. If your will says, I want all my assets to go to my spouse. If we're both passed, I want them all to go to my kids. Or, you know what, maybe it says when I pass, I have a revocable trust. And I want all my assets to go into my trust. Most times, those beneficiary designations, again, should mirror what your will says. So it should say my spouse first, my trust second, or spouse first, kids second. Again, however that's set up. So periodically, double check what your beneficiary designations are, make sure they're up to date, and they name the correct beneficiaries. Also too, again, because I mentioned trust, I find that such a common mistake, a planning mistake too, is a lot of time people set up revocable trusts, again, for probate avoidance purposes, or maybe for other reasons, because it's such a really good common planning tool. But also then they don't take the extra step of, and this kind of plays into not only updating beneficiary designations, but also reviewing how you own your assets. But they never take this extra step of, after they set up the trust, they never put assets into the trust. So they never retitle the house into the name of the trust. They never update their beneficiary designations to name the trust as the beneficiary. So they have this wonderful trust set up, but because they've structured their assets in a certain way, they're not really taking advantage of the benefits that the trust has to offer. So again, particularly if you have a trust, you really need to make sure you've funded your trust, or again, structured your assets in terms of beneficiary designations or other manners, to make sure when you pass, those assets are ultimately going to end up in the trust. So again, so important to know how you own your assets, so important to keep your beneficiary designations up to date. And last but not least, it's so important just to share your estate plan with the people that are going to either benefit from it or be in charge of it. So I know I'm providing a lot of just examples that I see in my practice, but I find it's helpful because to put it in context, because these are not kind of just, scholarly examples. These are real life examples that I see a lot in my everyday practice. Is that, for example, mom and dad did an estate plan and they never told the kids about it. They never told the kids what their assets were. They never told the kids what attorney they used or what documents they had in place. So when they've passed, kids are left scratching their heads going, we don't even know what mom and dad did. We don't know where the documents are. We don't even know if they had documents. Even if they have, we know where the documents are. Mom and dad didn't want to share any of their asset information. So we don't know where their bank accounts are. We don't know if they have life insurance policies. And it becomes very difficult and becomes kind of a detective game to figure out where are all the pieces of the puzzle. So to sit down with, again, either the beneficiaries, or most importantly, sit down with the people you've chosen to be in charge, the executors, the trustees, the powers of attorney. And at the very least, even if you're not comfortable kind of divulging the entire plan of what you're doing, at the very least, let them know you have these documents in place, that you've chosen them to serve in these roles. And again, you don't necessarily even have to give them copies of the documents. Just say, I just want to let you know, you're the person I've chosen to do, X, Y, and Z. If you have any questions, we keep our documents, in a certain place in our house, or we keep our attorney's card who prepared our documents here. You can always call the attorney. Kind of just leave enough breadcrumbs behind so where the people who are that you've chosen to help you actually have to come in and kind of pick up the pieces, they know where to begin. It's so helpful for them to have that starting point, so they're not, again, kind of in the dark, just wondering where everything is. But to the extent you do feel comfortable sharing more information, again, maybe it is sit down with those folks and read through the documents to say, this is the plan I have in place. I want to make sure Not only you guys understand what needs to be done, but maybe why we did what we did. Maybe if one person is getting a bigger piece than the other and you want it's for because that was the child that came in and helped you out a lot when again you were getting older and you needed help paying bills and everyday care. Maybe that's why they're getting a bigger piece. Or if you have again kind of in the example where you have your own business, maybe one child is getting the lion's share of the assets when you pass just because it's comprised of the business. They're going to be the ones taking it over, so they get that piece. So again, to sit down maybe and explain the plan could possibly avoid any questions or hurt feelings down the road if everybody is on board and understands why you did what you did. So again, not required. The amount that you want to disclose is completely up to you. But again, at bare minimum, I do recommend that you tell the people that you've appointed as fiduciaries, at the very least, you tell them where your documents are, you tell them who they need to call to get access to that information. So that's the information I have for you guys today in terms of your estate planning checklist. Year-end gifting, if you're so inclined, needs to be done by December 31st. You should always periodically review your estate planning documents. But again, year-end tends to be a good trigger to say, you know what, maybe this is a good time to pull them out, read through those, making sure your assets are going to the right places and you've appointed the right fiduciaries. Reviewing ownership of your assets, reviewing your beneficiary designations, and again, kind of talking through your plan with the folks that are going to need to implement it. So if anybody has any questions, you can feel free to type them into the chat, or also always feel free to contact us through our website. My email address is on our website, kkc-law.com. So you can always ask questions to us that way. Again, this is the final webinar for 2021. So I thank you for everybody who's attended the webinars thus far. We will be starting up with our webinar series again next year. So keep an eye out for that schedule once it becomes available, because I think we're going to have a lot of really good, interesting topics. I promise not only estate planning stuff. So there's going to be a lot of good information coming out next year too. So I don't see any questions being typed into the chat. So again, thank you for everybody who attended today. Happy holidays and a happy new year to you all. And please, again, feel free to reach out with any questions at any time. Bye.